Yes. Lord, I'll sum up in 15-20 minutes and Lord, on the last occasion, yes. Yes. Lord, on the last occasion, I had mentioned that it is very clear that the present system of Section 34 has created more problems than it has solved. It was intended to bring in a simple system of arbitration and so on, but it has actually created more problems. There's a rigidity in 34 which has to be addressed. And that rigidity has been partly relieved by the legislature, by inserting 34(2)(a), which is an admission. 34(1) by itself may not address problems which one may face, the courts may face while dealing with domestic awards. So Lordship will appreciate that 34(1) and 2, 34(2) deal with international awards and domestic awards, that is ICAs and domestic awards. But 34(2)(a) deals only with a domestic award. And there, Lord, they say that you can set aside the award to the extent of patent illegality, which was not the ground for 34(1). For 34 ground, you got the fundamental policy of India, shocking the moral conscience, etc. Now, my Lord, the point I'm making is this. Today, my Lord, we need not go into what is the meaning of patent illegality, what is the meaning of fundamental policy. That is not the remit in my humble submission of this bench. I am putting, sorry, Lordship,
please continue.
Yes, Lordship, 34. But the point I'm making, Lordship sees 34.
But 34 is an additional ground, not really a ground which permits. 34(2)(a)
yes,
is an additional ground
for domestic arbitrations.
But it does not permit segregation or division of an award per se.
Yes. Therefore, Lordship is right. What your Lordship is referring to 34(2)(a)(4), which says that, yes, maybe that's what your Lordship is. But my humble submission is, the point we are making, and I think there cannot be an argument against that the power to set aside will necessarily include the power to partially set aside. That's a well-settled principle in our constitution. The larger power includes the lesser power. You can't say either you set aside everything or don't set aside. To give a practical example, we'll have to see the law as to how it applies in practice. Now, all of us who have done arbitrations at some time, it is, in a sense, something like a civil case where there's a claimant instead of a plaintiff, we call it a claimant. Then there is a counter. Issues are framed. Invariably, my experience is the issues are framed by the arbitrators. If there's a counter claim, they'll take it together and issues are framed. Now, the point I made last time, at the time when the bench rose, was take a hypothetical case where the arbitral tribunal frames, let us say, 7 issues. Based on the pleadings, they frame 7 issues. And out of 7 issues, let us further assume that 2 issues, if I may use the word, are infected with patent illegality. They're infected with patent illegality. Now your Lordships have to decide. In such a case, do I set aside the whole award because it doesn't say partly, or the court can say these 2 issues are severable. They are severable. They are on a standalone basis. And I need not relegate the parties on all 7 issues back to the tribunal just because 2 issues are infected with patent illegality. Lord, my humble submission is the word set aside can't be given such a rigid meaning as to make it inflexible and put it into a binary of a black or white. And once there is a patent illegality, the whole award goes. So my first request is, Lordship may see set aside must necessarily include partially set aside. That must be given, power must be given to the court. And I would submit it is inherent in the court. That inherent power is there. But I'll show Lordship a passage from Ashok Hurra and Rupa Hurra in a different context on curative, where Justice Kadri says, we can't, once we see a patent injustice, we can't be a silent spectator and fold our hands and say we can't do anything. You can do. Lord, on this partial setting aside, I don't think there can be much of a, in my humble submission, much of a problem, because if the court is faced with severability, then it can't be said that if it's 34-2, I will sever it, but if it is 34-2, I will not sever it. That will be an illogical answer. That if I'm a domestic award and I'm under 34-2, severability applies. But if under 34-2A, a certain sense of rigidity comes in, that cannot be the answer. The larger, bigger problem on a day-to-day basis is this, Lord.
But then you are going on the assumption,
yes,
that severability is possible.
Yes, that's my first limb. What I'm saying is, Lordship will imagine a chart, patent illegality, severable, non-severable. If it is severable, then to the extent of severability, partially set aside the award. That is the first submission. Now the larger problem now comes in. Suppose there is a patent illegality. Now first division is severable patent illegality, non-severable patent illegality. Now I'm coming to the second classification, sub-classification. There is patent illegality, and it is of 2 types. It's a curable patent illegality and a non-curable patent illegality. But in my final submission, I'll draw the chart and give it to you. So I wanted to make the chart after getting your Lordship's reactions and hearing the other side also. And I'll show with examples how this court, where the illegality is curable, they have not set it aside and sent it back. They have cured it here and now. So what do I mean by curable and non-curable? What I'm submitting is, if the patent illegality goes to the root of the matter, just imagine Lordship is now hearing an appeal from the High Court. Lordship finds the judgment has to be set aside. There is nothing else can be done but to set it aside. The judgment is so unsustainable that the court sets it aside. At the same time, times innumerably, Lordship has partly allowed the appeal. Partly allowed the appeal. So my submission is, if the patent illegality is curable, why can't we say that the inherent power of the court includes the power to cure that illegality alone? And now if a Lordship reads the section carefully, 34, I want to make a submission that only if is not confining the powers of the court, the only if is a maintainability issue. Just read it with me 1 second and I'll go to my last part. 34.1 and 34.2, Lordship will kindly see. 34.1 says, recourse to an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 or subsection 3. So that means that the setting aside can only be on the basis of an application. Can't be a suo motu. Now, an award may be set aside by the court only if the party making the application establishes on the record. It's been substituted for proof. So my humble submission is, actually an arbitral award may be set aside by the court. There are 2 grounds. that only if must be linked only to clause A. Lordship will appreciate it should be linked only to clause A, because unless the applicant brings it within 1, 2, 3, 4, 5, the application will not be maintainable. Now come to B. The court finds that. The court finds that. So typically what we do in real life, in day-to-day, is in our 34 application, if the award is suffering from an infirmity under 34(2)(b), we also add that as a ground that the award is contrary to policy of India, or it's not capable of settlement under the law for the time being in force. That's not an arbitrable dispute. That we add it as a part of an application. But that is not necessary for the maintainability. What I'm submitting is B indicates that there is an inherent power given to the court to address a case where the arbitral award is on a ground which is not capable of settlement. Suppose the party had not taken that ground at all. He satisfies 1, 2, 3, 4, 5. He doesn't take the ground that it is not capable of settlement. Like the Lordship has held, it's complete fraud, forgery, it can't go for arbitration. He takes that point. Or it's in conflict with public policy. That ground is not taken. Can a Lordship say that, no, I'm bound by the pleadings? No. Lordship will say, look, I see the award. I see it's non-arbitrable. I see it's contrary to public policy of India. Therefore, I can interfere and set it aside. There my submission is in 34(2)(b). Also, it is not all or nothing. If there are 4 disputes, 2 are not arbitrable, those 2 can be set aside. If the remaining 3 are arbitrable, let it go. Let it continue.
No, that's provided in clause 4 itself. So
no, but not in 2B.
Not in 2B.
Yes.
Now, the difficulty, there are 2 ways to interpret, though it's not strictly within our domain.
Yes.
Or the reference. But if one looks at subsection 1,
yes,
the recourse to the court against an arbitral award can be only made on an application for setting aside of the award in accordance with subsection 2.
Yes.
Now, this will mean an application by an aggrieved party.
Yes.
But if we look at B, the court finds that, so it, logically speaking, it says it will be only unless the party has taken recourse to an application in terms of subsection 1, the court finding will not be there.
Correct. The court can't see when award is coming in the media, like I take under Article 2.
Or even if, say, executing court cannot.
Your Lordship is right. At the order 21 stage also, he can't say, no, it's contrary to public policy, therefore I'm. Because by that time it becomes final and binding.
Correct.
Yes. No, what I'm arguing is. Sorry.
The court hearing at 34 is not a creature of this statute. It is a court which independently exists.
It's a 2E court.
With its inherent powers.
Yes.
Under the old act also, 151 has been invoked wherever statutory provisions were, found to be deficient. Probably Ramji Dayawala in context of 34.
Yes.
Additionally, 154 to stay the suit. So we will also ask them, would 151 CPC be available to the court, because we can't treat the court as a tribunal which is a creature of a statute.
Yes.
It is a court which exists with its inherent powers. Additionally, the power is conferred in this statute. Power is drawn from the statute in excess of its ordinary powers of a civil court.
Yes.
So, what stops a court from exercising 151 powers where interest of justice warrants?
But can your Lordship also see?
Didn't provide in the old act.
Yes.
Scenario which invoke 151 to stay.
Yes. And your Lordship is right, because definition of court is the court of the ordinary, the highest civil court in that district. So it could be the charter court, or it could be like in Bombay, Madras, Calcutta and Delhi, it is the high court. And in Bangalore, for example, we go to the district court. City civil court.
Principal judge of the city.
Principal judge of the city. In Bangalore, Andhra, we all go to city civil. Nagpur won't go to high court.
Original site is only for me,
Only for.
only for Mr. Kambat. If read arises from, say, Mulund, it will go before a single judge. And if it arises from Thana, just across the road, it will go to the division bench.
No, from what your lordship is saying, if it's a Madurai bench, then again 34 won't lie. We'll have to go to civil court.
Because it lies only to
Quite possible. Principal court of that
Principal
place,
court.
yes. So, my lord, what in the light of what my lord Justice Vishwanath asked, recourse to a court, I mentioned yesterday on section 9 just before closing. Now,
So you can come to section 151 route. not
151 root also. Get the CP. 151 root also. Lordship will see 151. The same provision is also contained in Rule 6, Rule 9 of the Company Court Rules. In the Companies Act, they say so. They say that the court will have all the powers to do justice. You take Regulation 44 of the Income Tax Tribunal rules. Tribunal has all the powers to make in the interest of justice. Same thing in the CLB regulation. So what I'm saying is they confer it on a tribunal, but that need not be conferred on a court because the court has. Now the definition of court in 2 is 2(1)(e). Court means in the case of arbitration other than international commercial law, principal civil court of original jurisdiction in the district includes the High Court in exercise of ordinary civil jurisdiction having jurisdiction. Now my submission is following following Dulabai's case, old Hidayatullah judgment of Dulabai, unless the powers of the civil court are explicitly taken away, they will always continue.
implied that it will continue.
Pardon me?
It is implied that it will continue.
It will imply that it will continue. For example, the latest Companies Act, there is express provision that no civil court shall have jurisdiction to deal with matters of Companies Act. No civil court. Same thing, you take all the tax statute, no civil court shall. So the jurisdiction is ousted. So the law is basically jurisdiction is there. It has to be ousted. Here what they say is recourse to the court is there. So court has the power to grant relief. But that relief will be granted only on the basis of an application, as my lord the Chief Justice mentioned. Absent application, you can't act. But once the matter is in court, he expressly says the court finds that. And then they further amend.
Even if that ground is not raised.
Pardon me?
Even if that ground is not raised, but if the court finds that
Yes,
it
yes.
suffers from the clause 1 and
Yes,
of B,
yes.
the court will be empowered to exercise the jurisdiction.
Yes. No, this is not like the tax dispute. The question of law has not been raised, therefore I will not answer it. That is not the point. There also, will not they say in 260A, the power of the court is like the power of a civil court. Lordship knows 260A subsection 5. Even if you don't raise that question, the court can still deal with it. That is the, so throughout the theme is that you maintain the powers of the civil court. So I'll just complete my submission by saying recourse to a court means recourse to a civil court. Keeping in mind section 9 read with section 151. The inherent powers of the court to do justice are always there, and therefore set aside must include partially set aside. Now I came to this issue, I'll come back to the issue of severability. Now in 34. My lord, therefore, my lord, my submission is that the recourse to the court under section in the 34, there is an implicit power of the court. To what extent it is taken away is limited by 34(1)(2) and 34(4). What are the limits to which the court cannot go? They are set out in the explanation. Kindly come to 34, explanation 1. Please come to explanation 2 of 34(2). For the avoidance of doubt, the test as to whether there is a contravention of the fundamental policy of India shall not entail a review on the merits of the dispute. So this is like a red line which says that, at the heart of the day, they say don't make it a section 96. Don't convert it into an appeal. And my lord, perhaps the best discussion is that Lala Bansidhar's case from Delhi High Court which came. What are the types of jurisdiction? There is an appellate jurisdiction, there is a revisional jurisdiction, and there is a reference jurisdiction in the old income tax cases where the High Court's jurisdiction is only on a question of law. The tribunal continues to be in session of the matter. The High Court decides the question of law, and then the assessment order is passed in the lines of the High Court order or the Supreme Court order. So you have appellate jurisdiction, revisional jurisdiction, reference jurisdiction, and this is another kind of a jurisdiction called application jurisdiction, where it's a new type of jurisdiction. I'll give the Lala Bansidhar's case, very detailed discussion on what are the types of jurisdiction the High Court had. Let's get Lala Bansidhar. So there's an appellate, reference, revisional, and now it's an application where the power is limited. And what are the limits? One explanation is you can't do a review of the merits of the dispute. So as the Lordship put it, you can't get into the merits. You can't step into the shoes of the court. Lordship will note section 107 of the CPC says the power of the appellate court is as much as the power of the civil court. Under section 107 of the CPC, the appeal court can do everything which the law can do. Coextensive. This is not a 107 power because this is not an appellate court. So Parliament says, look, when you're discussing whether it's contravening fundamental policy, don't go to the review of the merits. Now, please see 2A proviso. Provided that an award shall not be set aside merely on the ground of an erroneous application of law or by a reappreciation of evidence. And it's erroneous application of the law, not a complete error of law itself. You apply the law erroneously. This is like the old Anismini case. Once you have jurisdiction, you can err within the jurisdiction. But suppose you apply the law completely wrongly, then your lordships have held it is perverse, irrational, and so on. So my submission is, section 34 has inherent power of the court. It is not taken away explicitly. The word is may be set aside. And the two explanations give a yardstick as to what can be done. Now, please come to 34(4) also, where also there's an indication. Now, 34(4) came bodily from the international commercial arbitration. Obviously, my lord, if the award is passed in ICC Paris or another country and it comes for enforcement to India, then what happens? In an international award, you're not an appellate court. You're not a court like 2E court. The definition of court in the UCITRAL is an Article 6 court, the court of that particular country. That court was not given the power to, they could set it aside and they could not enforce it. So what happened is, if it came before the court where the award was passed, they could be set aside. If it goes for enforcement, then the same grounds are there. For setting aside enforcement, same grounds are there. Now here what they did was, they said you can send it back to the tribunal. I'm requesting your lordship to read 34(4). What does 34(4) say effectively? That instead of setting aside the award completely, because 34(4) will come only when an application is filed under 34(1). But if an application is filed to set aside the award, typically the other side will say, don't set it aside fully. Here is a ground to set aside, but that ground can be remedied by sending it back to the tribunal. Can we not say it's a curable defect? 34(4), because setting aside is the death of the award. That is the last remedy. So what the 34.4 contemplates, instead of going to the extreme step, now the ground for setting aside the award can be, when they had 4, when they inserted 2A, they kept 4 as it is. So the ground to set aside the award can be a patent illegality ground also. Not sure appreciates that. They kept 4 as it is. Now the grounds to set aside the award are both in 34.2 and 34.2A. So the court will examine, the 34 court will see, look, this is the ground, yes, award can be set aside. Then you ask the next question, can I avoid the extreme step by sending it back to the tribunal? My humble request is, why not leave it to the discretion of the court to say, look, this is a matter where I need not send the parties back. If I can modify it, I can make change here itself, I can sustain the award. Why can't that power also be read into the inherent powers of the court? Why send it back? Because Lordship will see a practical difficulty. By the time the matter comes to the 34, 4 or 5 years have passed. And I spoke to my friends who deal extensively in arbitration. He's saying it's very, very often unworkable because the tribunal.
There's some difficulty in accepting this argument.
Very well.
Because if we accept that curable defects referred to by in your arguments, which the court can rectify, are relatable to subsection 4 to section 34, then it will lead to difficulty because 34.4 provides for a specific remedy.
Yeah. No, I'm not saying that you should
It
bypass.
can be argued by the other side that when a specific remedy and a method of providing for that remedy is, then we cannot
bypass it. Yeah.
bypass it.
No, what I'm submitting is, this is one indicia or one indication that if there is a ground to save it, because what I'm saying is 34.4 doesn't contemplate setting aside completely. 34.4 is a exit route or a window where you save the award by curing the ground on which it can be set aside. Now your lordships have interpreted 34.4 to mean it can't be a second bite at the cherry. You can't use 34.4 to make it like a review court and re-argue that case. So where the point is, now let's visualize what could be the ground to set aside the award. It could only be under 34.2 or 34.2A. Because patent illegality is a huge spectrum. It can be from a small thing to a large thing. We don't know.
But when subsection 4 describes a particular procedure.
I know that. I'm not saying that.
Nazir Ahmed principle. When a law requires to be.
Yes, Taylor versus Taylor thing done in a, yes, Lordship is right. Taylor, Singaram Singh, all the line of cases are there. You can't. I'm not saying that the court usurps the power of 4. I'm not saying that. The very purpose is given is, if this, now I'll tell you what, Lordship, what happens. Suppose the ground for set aside evidence is, suppose some documents have not been considered. In one issue, certain critical documents have not been considered. The other side says this issue has to be set aside because this critical document has not been considered. That has a material bearing. Now the 34 court can't go into appreciating evidence, summoning the document on. They'll say, all right, this document has not been considered. We'll send it back to the tribunal. Let them consider these documents and then decide the issue. That's what is 34 is contemplated. I'm on an illegality like a legal illegality, which doesn't require re-examination of evidence. I'm only saying, as my Lord Chief Justice is right, we can't say because 34.4 is there, the court can do the same thing which the tribunal can do. That is not my argument. That will be a wrong interpretation. I'm only saying there are various indications in 34 to say setting aside the award is the last resort. Wherever you can save it, try to save it. The only limitations are don't reappreciate it, don't do a review on merits. So my last submission, and I'll conclude with this, my submission is this. Partial set aside must be there. If the award is severable, my submission is, if the award is severable, because typically what will happen is multiple issues are there. It is not that all issues are patently illegal. Invariably, it will happen that 1 or 2 issues become bad. Like we all seen first appeals. When you go for a first appeal, the first court sees what are the issues framed, what are the answers on the issues, and then we argue that matter. All of us have argued first appeals and second appeals. That's what we do. But my submission is, apart from the classification of severable and non-severable, I'm now going into 2 points because curable and non-curable. Ultimately, we have to make sure that arbitration becomes a vibrant alternative force. Today, what's happening is with this kind of interpretation of saying that you can't touch it at all and all that, then people are going to be very hesitant to go to arbitration. And if I'm going to have an arbitration clause and after 7 years, I'm going to be sent back, no, now you set aside, start on your own, then what is the purpose? The whole purpose is completely lost. Then it doesn't become an alternative dispute mechanism. It becomes a dispute mechanism which will be forced upon me because I have no other power but to listen to the contracting party. If I have to get the contract, I have to sign that arbitration clause. Now, the second submission I'm making is, yes. Once you accept that there is a power to partially set aside the award, then my humble submission is leave it to the court because the limits are given here. Don't review on merits, don't reappreciate evidence, don't correct errors of law, application of law. Those limits are there. I'm saying, please examine this point, which I'll conclude with this. In my example of 7 issues, suppose the 2 issues are not severable. That infection affects the whole award. It's not severable. Then what does the court do? My humble submission is the court must then examine what is this patent illegality in these 2 issues which is infecting the whole award. If that illegality, patent illegality, doesn't require reappreciation of evidence, doesn't require correction of application of law, doesn't require a review on the merits, those 3 constraints, then the court can always say, look, instead of setting aside the whole award, I will remedy the illegality to the extent the illegality can be corrected, like a course correction. The award is off track, bring it on track and save it. And it has been done more than once. Lordship will kindly see both the statements. I'll give the example. Lordship will just note. Lordship will note citation. Indian Oil Corporation versus Ganesh Petroleum, 2022 4 SCC 463. 2022, volume 4, SCC 463. Here what happened was, the award altered the terms of the lease. They made it 20 years into 9 years or 10 years. They changed the rate of rent. Now you altered the whole thing completely. What did the court do? They said, no, if it's a 20-year lease, it should go back to 20 years and restore the rent. So what they did was, the award was modified to make it conform to the lease agreement, and it was then allowed to stand. That has happened. Then take State of Chhattisgarh versus Sal Udyog, 2022 2 SCC 275. The award did not consider an applicable government circular. It was modified to bring it in terms of the circular. Two more examples I'll give. Sangyong, the Honorable Supreme Court says majority's award is wrong. I'm taking the minority award as the correct award, which I think is a very extreme example of modification. Suppose there's a dissenting award. Under 34, can the court say that there are 2 awards in front of me? I will sustain the minority award. Or do you set it aside fully and send it back? Maybe one can take the view that if the majority is so patently wrong and the minority is a well-reasoned award, that's what been done by the Supreme Court. And lastly, Hakim. As far as Hakim is concerned, my humble request is.
Third one, you've not given us the citation.
Sorry,
Sangyong.
I'll give it in a minute. Sangyong and McDermott, I'll give both the citations. Sangyong is 2019. 15 SCC 131 and Hakim is of course in the referral order 2021 9 SCC page 1.
2021,
2021 9 SCC page 1. This is part of the referral order. That's Hakim. That is National Highways versus Hakim. And McDermott, which is Justice Sinha's judgment, 2006 11 SCC 181. 2006 11 SCC 181.
I think I'm party to Hakim.
Pardon me?
I was part of the bench in Hakim.
Part of the in Hakim, yes. And I think Mr. Justice Sinha was the counsel in Hakim.
Counsel.
no, I was not there.
Yeah, she's counsel in? Sorry. Yes,
What is the page number of Sangyong?
131.
13.
Now, my lord, I have also referred to the case law compilation which we have given. Please see Vedanta. Vedanta, if the court master can put it up. Where is Vedanta? Yeah, wait. Vedanta 2019 11 SCC, page 463,
2019,
11 SCC 46.
Page 416 of a common compilation.
465, it is page 416 of the common compilation. You know, all the cases are in the common compilation. Now, please come to para 11 of this judgment. If they can put it up. Twenty 1911 SCC 465. Please see para 11. That's important. May I read para 11? Read para 11. Yes. Yes. Please see para 11 in the screen. Lordship will see para 11 in the screen.
I've got the book.
Courts may reduce the interest rate awarded by the tribunal where such interest does not reflect the prevailing economic conditions. That's one part. Where it is not found reasonable or promotes the interests of justice.
Now, till this one, there are 2-3 things. Can the court also increase the rate of interest?
Pardon me?
Can the court also increase the
Yes,
rate
my
of
answer
interest?
is yes, because suppose the arbitral
That's one.
Just
Just one. Now, if one goes by that, that means this is a complete case of merit review. This is a complete case of merit review
No, I'll tell your lordship why.
because
Sorry.
it is rate of interest has an element of always has an element of discretion. Rate of interest always has an element of discretion until unless by statute that
Or by contract.
or contract is taken away.
Yes.
And as far as pendant light is concerned, it's always under 34 also a matter of discretion of the court. Now, if one looks at the rate of interest provisions also, it says that where the arbitrator has not awarded interest, post-award rate of interest, then the statute itself prescribes the rate of interest. Can the court then read down the rate of interest? Suppose the award does not prescribe the rate of,
Can I give an example? Lordship?
but because then it provides that. So in this case, will you not read down that the discretion of the court is taken away? Because by default, if the arbitrator has not awarded post-award rate of interest, then there is specified rate of interest.
But on the interest issue, there is a problem here because the contract is 18%. Very often, if the other side is a public sector unit, then the court says,
The reason why I say the increase in rate of interest, because most of the government contracts, there's a specific stipulation, no interest will be awarded.
no, let's come to a contract where interest is awarded.
So
Yeah.
the reason why I asked you
I
that
know.
was, and they're judges of this court, arbitrator is bound by those conditions.
Correct. In fact, in many of the government contracts, other problem is, as a tax lawyer, they say that the price is all inclusive. Even if there's a hike in the taxes, you have to bear the cost. It also has been held to be valid. I'm not on that. I'll tell you a practical problem which we have faced in Madras. Many of these finance companies are there. Now they give loans for sale for car and motorcycle.
Exorbitant, the rates of.
And now what they say, the interest is 18% per annum. Because they have to borrow at 12% unless they have the arbitrage, they can't sustain. There is a clause that if you default for more than 3 months, the interest becomes 24% or becomes 36%. Now, in the light of what your lordship said, in many of these things, there are arbitrations where they appoint lawyers to the small arbitrations. The default is 2,80,000 like that. Very often they seize the vehicle, only the balance they have to recover. Now, my submission is if the contract says that a defaulter has to pay instead of 18, 24%, and if the arbitrator awards only 18, ignores the contractual rate, my humble submission is the court can change it in the interest of justice to 24. Why not? That's my question. And in fact, our High Court or the Honorable Supreme Court has held, you can't have a separate yardstick for government companies. You can't have some kind of sympathy. If they have the clause, then they have to also have the thing. But to answer your lordship question, can you increase it? You can increase it to make it in terms of the contract. Only one thing is there, my lord. On interest, please come to section 28 of the Arbitration Act. That's very important, which we lose sight of. Section 74 of it. 28 is again borrowed from the UNCITRAL. They have modified it in India. 28 is very important. Again, it is peculiar for domestic arbitration. May I read 28 1A, my lord? 28 1 small a. The lordship's got it, my lord? Yes. Where the place of arbitration is situated in India, in an arbitration other than international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. Now, this is a mandate given by the legislature. Once the arbitration is being held in India, if the place is in India, then the substantive law of India applies. Now, lordship gave the example of interest. What does the Contract Act say? The penal interest, the lordship takes section 74 of the Contract Act. They say that a clause, suppose I say it's 18%, but if default it is 48%. Suppose I make it highly issued. Then the Contract Act says such a law is in terrorem. It's in the nature of a penalty. It is not permissible. So the arbitrator can always say he has to decide in accordance with the substantive law of India. Section 23 of the Contract Act. If a clause is against the public policy, the agreement is void to that extent. So I am saying that the patent illegality can also be seen from 21A. If the arbitrator has ignored the substantive law of India, then the remedy is either to set aside the award or to make sure that it falls in line with the substantive law of India. Why set it aside? If you can just, like my lord the Chief Justice gave the example of a formula. The arbitrator has not completely applied the formula, he has missed one particular part of the equation. You can just change it to that extent. Why send it back for that purpose? That's my submission. So my lord, I'll just conclude by saying that one more thing as far as Hakim is concerned. My lord Justice Vishwanathan asked the question, what about reversal? Set aside and reversal. My submission is, suppose the particular issue in the arbitral award has taken view X and the correct substantive law is view Y, then it need not be set aside. The arbitral tribunal, the section 34 court can simply say, look, I'm ignoring X, I'm going to put it as Y, which is exactly what your lordship did in Sal's thing. You said, you ignored the circular, I'm applying the circular, I'm doing it. To that extent, it is a reversal of what the arbitral award did.
Is that not varying? Is varying different from modification?
But we thought about it, we discussed it. But basically, we are on a fundamental basis. When the lordship partially sets aside the award, are you not modifying the award? So are we not on a question of semantics? What is modifying? What is varying? In the long run, we will have to come to a situation where we adopt some of the clauses like Singapore, UK, which learned solicitor has given, where there is the express power to modify the award, vary the award. Please see section 48 of the Singapore law, which it says, he has quoted. It says the court shall not modify the award under any circumstance, except as provided in the Act. That's 48 of the Singapore Act. 49 then says, a domestic award can be varied, modified. The lordship sees learned solicitor's notes. You quoted section 48.
48 is
There is a bar.
in principle similar to section 5 of our Act.
No. 48 says,
47.
no, see, 47 says, Lordship will kindly note section 47. In Singapore, the court does not have jurisdiction to confirm, vary, set aside, remit an award on arbitration and agreement except where so provided under the Act. And provided under 49, and under 49, they say the court can, in that on appeal, the court can confirm the award, vary the award, remit the award in whole or in part, set aside the award whole or in part. Singapore 49(8), 49 subsection A. Therefore, my lord, my humble submission is, ultimately, as I gave that note, I would request the court to add the words. I gave the chart on the last occasion, where repeatedly the court have added a few words here and there to sustain the award. And I also mentioned the court, Justice Vishwanathan noted it, on Seaford Court Estates with Lord Denning. Can I take that passage? No, I'll just give it in the course of my reply. Well, what Lord Denning says is, he says, acts of parliament are not made with divine prescience. English language is an imperfect instrument. So the act of legislature cannot cover every possible eventuality. Will the court master have the Queen's bench? Otherwise, Lordship will note the citation. Lordship will just bear with me. I'll just give it. The Seaford Court Estates Limited versus Asher, 1949. 2 all ER, 1949, 2 all England reports, 155. Last time I gave it to the court master. 155. And Lordship will then come to the concurring judgment of Lord Denning at page 164. If the court master can put it, 1949, 2 all ER 155, I can show it. Otherwise, hey? Yeah.
All England reporter, not all India reporter.
All England report.
All ER.
All ER. May I just read that passage, Manoj?
Yes,
Can I just read it and I'll conclude?
yes.
It's at page, starts at 155, Lord Denning's concurring views at page 164. Very nice passage. I'll read, Manoj. Whenever a statute comes up for consideration, it must be remembered that it is not within human powers to foresee the manifold set of facts which may arise, and even if it were, it is not possible to provide for them in terms free from all ambiguity. The English language is not an instrument of mathematical precision. Our literature would be much the poorer if it were. This is where the draftsmen of Acts of Parliament have been unfairly criticized. A judge, believing himself to be fettered by the supposed rule that he must see the language and nothing else, laments that the draftsmen have not provided for this or that, or have been guilty of some ambiguity. It will certainly save the judges trouble if Acts of Parliament were drafted with divine prescience and perfect clarity. In the absence of, now this is the problem, in the absence of it, when a defect appears, a judge simply cannot fold his hands and blame the draftsman. He must set to work on the constructive task of finding the intention of Parliament, and he must do this not only from the language of the statute, not only from the language, but also from a consideration of the social conditions which gave rise to it, the mischief it was supposed to remedy, and then supplement the written word so as to give force and life to the intention of the legislature. To put it in homely metaphor, a judge should ask himself the question, how, if the makers of the act had themselves come across this ruck in the texture of it, they would have straightened it out. He must then do as they would have done, that legislature would have done. A judge must not alter the material of which the act is woven, but he can and should iron out the creases. So my humble submission is, by adding 3 words as I suggested, lordships are not altering the fabric, you are ironing out the creases. I'm grateful.
My Lord's permission, may I follow Mr. Datar? But I am appearing in IA 9364 and 9401 of 25. Not. I've also prepared an additional compilation of just the judgments that I wish to show my lords, which I will take my lords. Earlier I had filed a 3-volume, but I think this is much more handy. Just share it. The aim of arbitration, as my lords have held, in the interplay with stamp act judgment, is to provide speedy, efficient, and binding resolution of disputes. And there's a delightful passage from Redfern and Hunter, which my lords have also quoted there, which starts with the advantage of arbitration is expedition where the law is slow. The act itself, apart from the objects and reasons, has a lot of internal evidence to show that speed and finality forms the fulcrum of the act. Very briefly,